Hello everyone and welcome to today's Mondaq webinar in association with Adams and Adams and an expert panel who will be exploring how you can unlock your IP in the world's largest free trade area. My name is Jenna Joyner and I am joined by a brilliant panel to take us through today's discussion. Mohammed Jamil Hamid is a qualified attorney and trademark practitioner specializing in the filing and prosecution of trademarks throughout the world with a special focus on Africa. He is experienced at conducting portfolio reviews and developing trademark strategies, having spent a number of years in intellectual property litigation prior to joining the trademark prosecution team at Adams and Adams. Natabi Shang Paswana is a partner in the Africa Patent Department, responsible for filing, prosecution and transactional matters in respect of patents and designs throughout African countries outside of South Africa. Natabi Shang joined Adams and Adams in 2007 and has been responsible for patent and design inquiries, transactional matters in respect of patents and designs, as well as filing and prosecution of patent and design applications throughout African countries outside of South Africa. Nicole Smallberger is a partner in the trademark litigation department of Adams and Adams. Nicole Smallberger advises clients from a wide range of industries, including, for example, the consumer goods, retail, agriculture, automotive, construction, telecommunications, entertainment, and IT industries in relation to the protection and enforcement of their brands and intellectual property rights in Africa. Dani Domen is a partner at Adams and Adams in the patent litigation section. He specializes in patent design, plant breeders' rights, and intellectual property agreement litigation, commercialization, and opinion work. Dani has for several consecutive years been ranked in Tier 1 for patent litigation in South Africa. And finally, Godfrey Budelli is a partner in the firm's trademark and copyright litigation section and head of the anti-counterfeiting and anti-piracy team. His area of speciality includes customs recordals and training of law enforcement officials, order and in-market enforcement, in-market survey and in-depth investigations, parallel or grey goods and online enforcement, civil high court litigation and supporting criminal prosecution, watching brief relating to criminal cases in relation to anti-counterfeiting on the African continent. Before I hand over to the panel to begin today's webinar, a housekeeping item for you. You can submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during the Q&A session, but please do reach out to them after the webinar for additional information. It's now my pleasure to hand you over to the panel to begin.
Thank you. Ladies and gentlemen, our panel comes to you from sunny South Africa. It's just after 4 p.m. and it's a beautiful African day. There's an African proverb that says, "One tree is not a forest." Is understood to mean that a lone tree is not a forest because it cannot establish a consistent local climate and is at the mercy of the wind and weather. There are 54 countries in Africa, and more than 60 years ago, they realized that Africa requires regional integration to become a forest. Clearly, the member countries appreciated that without integration, they were merely lone trees in close proximity and nowhere near a forest that could withstand economic and other headwinds. Today's discussion will not be esoteric. My partners and I will speak plainly about IP in Africa and what effect, if any, we can expect of the African Continental Free Trade Agreement and the IPR Protocol. We will also try to capture current IP affairs in Africa so that our comments today can be useful in your present roles. Before we depart on this journey, it may be useful to understand the lay of the land, as it were, from an IP perspective. So Africa is a big continent and comprises 54 jurisdictions, and essentially there's a national IP office or one of 2 regional IP offices covering all the jurisdictions in Africa, save Eritrea, where IP protection remains problematic at best. Several countries in Africa have also acceded to the Madrid Protocol, but validity of the international registrations, as well as the ARIPO registrations, which is a regional office, remain questionable in some territories. Be that as it may, for the purposes of our discussion, it is enough to know that IP rights are recognized and can be protected and enforced throughout Africa. But the strategy of protection and enforcement requires some veering between the national, regional, and international IP systems. Let us now discuss the African Continental Free Trade Agreement. For expediency, I will merely refer to it as the FTA, i.e. Free Trade Agreement, and I will refer to the Intellectual Property Rights Protocol, which is an annexure to the FTA, as the IPR Protocol. Before dealing with the evolution and implementation of the FTA and IPR Protocol, I will begin with a synopsis of the African landscape from a legal and trade perspective. This will give us some insight into how business should position themselves in the coming years when it comes to IP in Africa. As I've mentioned, there are 54 jurisdictions in Africa. Africa boasts over 2,000 languages and holds 30% of the world's mineral resources, including diamonds, gold, and precious metals. While economic disparity exists, several African countries are experiencing rapid economic growth, with Ethiopia leading the pack at 9.4% GDP growth in 2023. In fact, of the top 20 fastest growing economies in the world, nearly half are countries in Africa. With a median age of just 19.7 years, Africa has the youngest population of any continent. With fertile land, abundant resources, and its young growing population, Africa holds immense potential for future growth and development. Now bear in mind that nearly all of Africa was colonized, with the exception of Ethiopia, Liberia, and Morocco, which maintained varying degrees of independence throughout the colonial era. As a result, Africa features a diverse legal landscape, reflecting a rich tapestry of countries and economic systems, and we find that local laws, as well as IP laws, have been significantly influenced by other legal systems. Currently, most African countries follow a registration-based system, similar to other regions. This means that businesses need to register their IP, like trademarks, with designated national offices to gain legal protection. I'll now move on to what should be slide 2 of my presentation. Please, Joanna, if you can move the slides for us. Turning my attention to the African Continental Free Trade Agreement. The African Union is a continental union consisting of the 54 member states located on the continent of Africa. In 2018, it adopted the FTA, which will create the world's largest free trade area, comprising 53 of the 54 African Union member states, with a combined population of 1.4 billion people and a total GDP of 3.4 trillion US dollars. The only African country that has not yet joined the FTA is Eritrea. It appears that the FTA was inspired perhaps by the success of the European Union. When the FTA was adopted in 2018, we took the view that it would be fairly innocuous for many decades to come. After all, it was already more than 50 years in the making. To this end, I want to set out the timeline of the FTA so that you can see for yourself the pace at which developments are now moving. It all began in 1963 when the Organization of African Unity, the predecessor to the AU, established the idea of an African common market. More than 20 years later, in 1989, the Lagos Plan of Action aimed for economic integration and a continental free trade area by the year 2000. A further 20 years on, in 2012, the AU Summit endorsed the establishment of the FTA by 2017. In March 2018, the FTA was finally signed by 44 countries in Kigali, Rwanda, and 1 year later, in July, the agreement was entered into force after 22 ratifications. In January 2021, trading officially began under the FTA, and in July that year, the Guided Trade Initiative, otherwise known as the GTI, was launched, allowing eligible countries to start trading even before fully implementing the FTA. In November 2022, the FTA e-tariff book was launched, providing a digital platform for easier access to tariff information. And on 31 January 2024, South Africa, one of Africa's largest economies, witnessed the launch of preferential trade under the FTA by President Cyril Ramaphosa at the port of Durban, beginning a new chapter in Africa's trading route, promoting intra-regional trades, opportunities, and the like. You will note that it took the African Union about 50 years, from 1963 until 2017, to bring the conception of the FTA to life. But within just the last 5 years, the progression has been substantial and tangible, with the introduction of trade initiatives and special tariffs. I'll now move on to slide 3, where I'll deal with the IPR protocol. Joanna, if you can move the slide, thank you. The IPR protocol is a legal instrument obliging member states to promote and protect intellectual property across the continent. It is one of the annexes to the Free Trade Agreement. There are 7 in total. It was adopted on January the 21st, 2021. The IPR protocol aims to create a harmonized framework for the protection and enforcement of IP rights, as well as establish a modern system of IP protection that reflects African countries' needs and priorities while meeting international standards. It outlines the protection and enforcement of various forms of IP rights, including patents, trademarks, copyrights, trade secrets, and geographical indications. On 19th February 2023, the Assembly of the African Union issued a decision adopting the protocol and directed the FTA Secretariat to develop the necessary annexes to the IPR protocol and submit them to the relevant FTA institutions for consideration. This decision, it is envisaged, will gradually lead to the process of domestication of the protocol into the national laws of member states to the agreement. Although the IPR protocol was adopted in February 2023, its full implementation requires further steps at both continental and national levels. At continental level, there needs to be broader ratification of the protocol, at least 22 ratifications. Currently, no countries have yet ratified the protocol, but we expect this within the coming year. The FTA Secretariat at continental level needs to develop regulations and guidelines to ensure consistent interpretation and application of the IPR protocol across member states. National IP officers and other stakeholders need capacity building to effectively implement the protocol, and there needs to be harmonization of national laws. To some extent, this is already happening, as we have seen recent upgrades to the IP legislation in Malawi, Zambia, not necessarily instigated by the IPR protocol and perhaps by TRIPS and other treaties, but nevertheless, these developments tend to be happening. We anticipate that the aspirations of harmonization will inevitably have to include better compliance of member states to the TRIPS agreement. Currently, we find some territories in Africa have high compliance with TRIPS, and instances there are also where countries have little to no compliance. That was on a continental level. On a national level, we need to see domestication of the protocol, establishment of enforcement mechanisms, and stakeholder engagement. Overall, implementing the IPR protocol is a complex and ongoing process that requires sustained efforts from all stakeholders at both continental and national levels. When it comes to harmonization, the roadmap used by the EU in its transition from fragmented national systems to a harmonized system of IP laws may be instructive. Without unpacking all the steps, it is sufficient to mention that IP owners may find themselves in uncomfortable situations when their rights are suddenly competing for recognition within broader jurisdictions than initially envisaged. As was the case in the EU, many compromises will need to be made, and an important lesson learned from the EU exercise is that a broader and strategic representation among African countries will serve IP owners well in the impending transition. I now move to slide 4. The harmonization, if you can move the slides for us, please. The harmonization of standards and regulations of the diverse legal and other governing systems in Africa is not the only impact of the FTA and IPR protocol. We must recall that the function of the FTA is to ease the flow of goods and services throughout Africa. This will impact IP owners as the trade in their goods or services may extend to territories not previously envisaged. This is important for two reasons. In the absence of the registration of IP in these extended territories, brand holders may find that their goods or services are barred entry from some markets. This means that they will not benefit from the eased flow of goods or services. Secondly, unless adequate IP protection is founded in these extended markets, it may be difficult for brand holders to enforce their rights, which could prejudice trade in these specific goods or services. Adams & Adams has 23 associated offices across Africa. And with the benefit of this insight, we find that in developing a suitable IP strategy, it is necessary to consider the following. What types of IP can be protected in a particular African jurisdiction? The benefits of using the national system over regional filing systems or the Madrid Protocol. The costs of obtaining and maintaining trademarks must be weighed against expensive litigation costs to recover a mark. Whether a jurisdiction has special requirements, such as first to file, recognition of user rights, and well-known marks. How intra-regional integration may affect the flow of goods, and how to prioritize jurisdictions of interest. So, in conclusion, and in the main, IP owners are advised to review their IP strategy in Africa, and in anticipation of the harmonization process and intra-regional trade, should also incorporate a defensive strategy, particularly when it comes to trademarks. Ladies and gentlemen, thank you for your attention. I hope that was informative, and I will now hand over to my partner, Ntavi, from our Patents and Designs Department. Ntavi, over to you.
Oh, thanks, Jamil, and good afternoon, everyone. I will be talking briefly on the impact of the trade agreement and the IP protocol on patents and designs. And I believe that, for us to come to some conclusion as to whether the trade agreement and the IP protocol will be moving the continent forward, we have to look at the current landscape. We have to look at what currently Africa offers from our patents and designs perspective. So over the years, African countries have been acceding to international treaties that regulate IP protection for patents and designs. And we see that the increase in membership, currently we are sitting at about 49 to about 51 countries, African countries that are members of the Paris Convention and also the PCT. And also a few members have recently joined the Hague Agreement, which regulates international registrations of design. Unfortunately, we still have exceptions, and countries like Somalia, Eritrea, South Sudan, and Ethiopia are still lagging behind when it comes to acceding to international treaties. Be that as it may, in addition to this international treaties, we have two regional organizations, which Jamil has touched on some of them. We have ARIPO and OAPI, and these two organizations, they differ in membership, they differ in procedures, and they also differ in enforcement. Currently, ARIPO has 22 member states, which are mainly English-speaking countries, with an exception of Cape Verde and Sao Tome, which are Portuguese-speaking countries, whereas OAPI has a membership of 17 states, which are mainly French-speaking countries. When it comes to procedure, you must just bear in mind that OAPI they rely on a formalities system. So once you have filed and you completed the documentary requirements, you are bound to have a registration of patents or design within 6 months. So they are very quick. Compared to ARIPO conducts a substantive examination. They have a fully fledged substantive examination system where the applicant is required to request examination. The applicant will receive an examination report, and they'll also receive office actions, and applications will proceed to grant only after you have responded to the examination report or the office action that has been issued. It is important to note that the substantive examination currently is done for patents only. It does not extend to designs. Of interest also is to note that whilst these two regional organizations have proven themselves to be very effective to provide predictable timelines, to provide rights that are enforceable, some of our larger economies or IP officers are not members of ARIPO or OIP. So I'm talking about countries such as South Africa, Nigeria, Egypt, and Ethiopia. So based on this international treaties and the regional organizations, you can see that Africa as a whole, we do have a solid foundation of protecting designs and patents. We are not lacking behind, as people might think. There has been improvement, and this improvement will enable the trade agreement and the protocol to come into effect without lots of teething problems. So looking at what we currently offer as IP protection, like I said, we African countries are members of the PCT convention, Paris Convention. So that enables, or it has, these two treaties have been enabling applicants, to file PCT national-based applications. They've been able to file regional applications. They've also been able to file convention applications. And amongst these countries, we have countries that have managed to have sophisticated systems that enable them to issue quick grants of patents or designs. And these countries such as South Africa, Nigeria, Seychelles, and the OIP office. Between these countries and the OIP office, you should be able to get grants or registration within 6 to 12 months after filing and completing your documentary requirements. Also, we still have a unique system where we have a system called a patent importation, wherein a foreign granted patent can be registered into DRC and Ethiopia. So anytime during the lifespan and whilst the foreign patent is still valid, you can decide whether you want to extend it into DRC and Ethiopia. We also have a new phenomenon where the European Patent Office has been in talks with other African countries to provide for validation of European patents. Currently, there are two countries, Morocco and Tunisia, which have concluded the validation agreement, and it's possible to extend European patents, European granted patents into Morocco and Ethiopia and Tunisia. We are also aware that the EPO has been in talks with the Nigerian Patent Office, and they're also hoping to take the conversation with Ethiopian Patent Office or WAPI office in order to try and establish whether the system of validation of European patents can be extended to those countries. But it will be interesting to see how this will end, taking into account that the countries that they're talking to have already acceded to the trade agreement. So we also have, like I said, we have few African countries that have acceded to the Hague Agreement on international registration of designs. This is similar to what Jamil has spoken about as far as Madrid Protocol on trademarks is concerned. As much as our countries have acceded to this international treaty, the problem is we still have teething problems. The systems are not at a stage where we can say with surety that the rights that are registered through the Hague Agreement will be enforceable in those African countries. And it is for this reason that we still recommend to our clients to still proceed with filing nationally, to file regionally in ARIPO and OAPI, because it's cheaper, and you'll still be able to get a quick grant. Can we move on to the next slide, Jenna? So having said that, and having spoken about the next slide, having spoken about what the landscape is and what we are currently offering as a continent, we're looking at the trade agreement, and the question is, what does it bring? What are the implications as far as patents and designs are concerned? Jamil has already spoken about harmonization of IP system. Based on my presentation, you would have picked up that we have quite a fragmented system that doesn't talk to each other. And it makes it difficult to market or to portray the continent as a economic community because of all these differences. So with the trade agreement and the IP protocol, we are hopeful that we will kind of speak the same language. We will have a simplified system, a unified system to a certain extent that will not be attractive to only Africans, but also will be attractive to the world as a whole. And the protocol and the trade agreement also look into expanding protection that is offered. Unfortunately, some of our African countries are still lagging behind regarding the types of protection that they offer. They still offer the traditional patents and trademarks and then designs. But then with this protocol and the trade agreement, there will be expansion of rights that will extend to plant breeders, will extend to utility models, and also it will look into emerging technologies. And I think that's where the role of AI and IP will be coming into play. We're also looking at capacity building. Like I said, the two regional organizations that we have proven themselves to be very effective. So we will, I believe that this IP protocol and the trade agreement will be looking at something similar to what the two regional organizations will be are currently providing. And we'll be looking at knowledge sharing, training of our registrars, training of officials, and then also training of the judiciary and automation of the system. This will enable the different member states to talk to each other and also to see what the others are doing. The trade agreement and the protocol also brings into aspect the issue of monitoring and compliance. Like Jamil said, they're not bringing in a third IP office that will be dealing with registrations. They are bringing in an IP office that will be regulating the communication between the state members and the current regional offices and the international offices. And the Office of the Secretariat will also be responsible to make sure that member states comply with the protocol and also they also comply with the trade agreement. So what will happen, the intention here is that when a member state is amending their law or they are entering into any other international treaty or a regional agreement, they have to notify the Secretariat so that the Secretariat can check whether whatever proposals that they will be coming up with are in line with the spirit, the purpose, and the objectives of the trade agreement. So what is the role of our two regional organizations as far as the trade agreement and the IP protocol are concerned? The good thing is that these two regional organizations will remain. They are not going to be scrapped. So they'll continue doing the good work that they've been doing over the years. ARIPO and OAPI will assist the member states with technical assistance and capacity building. As we might know, I mean, ARIPO has qualified examiners, so they will be able to share the knowledge. They'll be able to train others, people from other member states as to how to conduct substantive examination and the pitfalls that they should look out for. And also, based on the protocol, it appears that the regional organizations will also play some role in formulating the annexures to the protocols. So these annexures will detail how each IP right will be dealt with. The next slide, please, Jenna. So currently, we are sitting with about 47 member states of the trade agreement, and not all of ARIPO or OAPI member states have acceded to the trade agreement. And what does this mean? Should it happen that the protocol comes into effect with the current membership of the trade agreement, how will things change? Nothing, to tell the truth, will change. ARIPO will continue as it is, OAPI will continue as it is. It's a pity that countries where you would like to see change have not yet acceded to the trade agreement. Countries such as South Sudan, Somalia, Eritrea, those are the countries that it has been difficult for us to obtain patent and design protection. But other countries such as Botswana and Liberia, which are members of ARIPO, things will continue as they are. We will still be able to file national applications, or we'll still be able to file regional applications through the ARIPO protocol. So we're just hoping that with this trade agreement, countries that are struggling will be able to benefit, and that will be beneficial to intercontinental trade and also for the world as a whole. So next slide, Jenna. In conclusion, Jamil has already mentioned it. We have a network of offices throughout African countries. And through these African offices, we will put our ear on the ground to make sure that we are up to date with what's happening, what the national offices are planning to do. And we'll also try to get involved as much as we can to assist with experiences that we have and also to share the expectations of our client. And on that note, I thank you. Thanks. I'll be handing over to Nicole and Danny.
Thank you very much, Ntabi, and Jenna, thank you for the introduction and the start. Nicole and I will be looking briefly at enforcement of trademarks. Nicole will deal with that, and patents on a couple of the African countries and throughout the territory. And we thought it important to put up this first slide. Just we speak about the 54 countries, but it is important to visualize just how big the African continent is. And one just has a look at this slide. The land mass of Africa is as big as a combination of the United States, all of China, all of India, most of Europe, Japan, UK included. And the important bit regarding the continent is that all these different jurisdictions have got different legal requirements, policies, and nuances. And just like a patent owner or IP owner won't treat his IP the same way in China that he would in the United States or in France versus Japan, those nuances, those considerations of what happens in different territories in different parts of Africa must be considered. It is definitely not a system where one size fits all. And then the further consideration that people must remember is if something happens in an IP regime, say at the Horn of Africa, which is somewhere in this map in India, that doesn't necessarily affect the IP regime on the west coast of South Africa or on the of Africa, and on this map, the west coast of the United States. So it is a big continent, and one must be careful and have a systematic approach to IP throughout the continent. And yes, the FTA may result in a standardization and a unified approach to IP, but we're not there yet. And until that happens, a strategic approach must be followed. Next slide.
Yes, so Donnie, I agree entirely. And the free trade agreement certainly sparks interest in IP circles around whether this may ultimately result in an all Africa filing system, a one-stop shop, but that certainly doesn't seem to be the intention. If it ever is, it would be a long time in the making. And as we've already mentioned in the preceding presentations, there are already regional systems in Africa. These are systems from which we could potentially learn lessons. These regional offices will be involved in the IP regime under the free trade agreement. So if we turn to the first that we should certainly mention, that is the Organisation Africaine de la Propriété Intellectuelle. And if there are any French speakers listening, please let me know where I went wrong with that in the comments. It's ORP to the rest of us. So there are ORP member states, 17 of them. And what makes ORP such an attractive system from the trademark enforcement and rights perspective is that it ring fences the entire region. So one ORP trademark registration will secure you protection across the entire region in all 17 member states. That is certainly attractive. From an enforcement point of view, we have had great successes over many years of opposing trademark applications filed under the ORP system, defending oppositions, and relying on ORP trademark registrations in the enforcement of rights. Some practical pointers that are relevant to an enforcement strategy in this region. It's important to note that there is no centralized dispute resolution tribunal or court. So should you find an infringement in one member state and perhaps another on the ground, you will need to institute high court proceedings in each member state. So you would be running parallel proceedings. Of course, these countries all have their own procedures, their own regulations, their own practices on the ground, and that means that it can be difficult to predict how litigation in Mauritania might run in terms of time frame, costs, practical steps, as compared to Cameroon, for example. So there is some divergence in that regard, and the same is applicable in terms of non-use cancellations and invalidations of marks. Those are dealt with through the court systems in the relevant countries. ORP, however, the main takeaway from an enforcement perspective, we're certainly confident and very comfortable with ORP, and it is recommended that rights owners and in-house legal teams look to ORP for protection on the trademark side of things. Then if we turn to ARIPO, that is the African Regional Intellectual Property Organization, a little easier to pronounce. ARIPO has rather, I think, a different experience on a practical level from the patent side of things as to compared to trademarks. So from the trademark point of view, if I could sum up ARIPO in one word, I would say uncertainty. So if you look at the map on our slide, the ARIPO countries are colored in blue. It's a vast area. And unlike ORP, it's not a total coverage through one application. You would designate the states of interest where you wish to secure rights. The difficulty, however, is that not all of these states have nationalized the obligations that they have under the Banjul Protocol into their local laws, and that casts a big question mark around enforcing those trademarks on a national level. So an important consideration when looking at ARIPO from the trademark point of view is, am I going to have a mark that I can assert, a right that I can enforce once I've secured my registration? The application process here will have to be considered carefully in collaboration with your Africa IP legal advisors so that you can be certain that you have an enforceable right, and there may in some instances suggest a national filing either as an alternative to designating this particular state in ARIPO or perhaps as a parallel option.
Yeah, thanks, Nicole. On the patent side, very much a similar scenario in ORP. All the ORP states have, or none of the ORP states have got national IP legislation, so they rely on the ORP agreement to govern the intellectual property side of things, and enforcement is done through the local court systems and the local rules of court and enforcement of general rights. So from a patent perspective, a lot more difficult to enforce in the ORP countries, and we see less litigation there. The ARIPO countries, as Nicole mentioned, out of a registration and a validity perspective, works perfectly well as long as you designate the correct countries that you want your ARIPO patent to extend to. You will get your national rights, and again, in ARIPO countries, you will then, once you've got a registered patent in a jurisdiction, enforce in that jurisdiction under the IP laws of that jurisdiction and then through the courts of that jurisdiction. We see, I think as Ntabi Singh has mentioned, a lot of English-speaking countries covered by the ARIPO system, and most of them have got English law as base for their enforcement procedures, and it's generally a lot easier and more reliable to enforce your patent rights in these repo countries. The countries that fall outside of these two systems, of those, South Africa is probably the most important. We've got large volumes of case law. We've got case law that goes back more than 100 years on patent enforcement, and the systems work well. It's very predictable. Other countries that fall outside of these regional system, Angola, DRC, probably less predictable and more difficult to enforce. And again, it brings one back to the point that there's no one size fits all, and one needs to take advice depending on the jurisdiction that you're looking at enforcement for patents. But I think Nicole must chat about Madrid, because Madrid in Africa creates all sorts of other problems. So I'm just going to stand back and let you go.
So if we can move on to the next slide. One cannot discuss regional systems without making mention of Madrid. And if our viewers have a look at the map that appears on the screen now, the countries colored in blue are all members of Madrid. And at first glance, this seems very attractive. You can see there's a vast area covered, very many countries. But unfortunately, from the trademark perspective, when it comes to enforcement of rights, my comments around Madrid and international registrations align with what I said regarding ARIPO trademarks. Very few Madrid member countries have domesticated amendments into their national laws to give effect to the protocol. So there are question marks around enforcement of those trademarks on the national level. There are also practical issues when it comes to the filing process and the prosecution of trademarks. Some trademark offices simply cannot examine trademark applications within the prescribed period, so there's then no substantive examination, though the mark will be deemed to be registered. That creates a question around, is that mark then enforceable? Can it be attacked? Can you rely on it? That being said, there are good IPOs that have got Madrid under control and handle it quite well. Morocco, Tunisia, Kenya, and Mozambique are worth a mention. And in others, where there are question marks around enforcement, we find that on a practical level, these marks are recognized and they are being enforced. We've, in OAPI, for example, relied on IRs as grounds to oppose applications. We've defended oppositions against IRs, and we've also enforced them. So there is some divergence in terms of, are these rights enforceable? Well, they are being enforced on the ground. Again, I think that reinforces the concept that Africa shouldn't be just taken for granted when it comes to Madrid, that you will secure rights everywhere. There needs to be a focused and honed in consideration of the countries that are of interest and importance, and whether the Madrid system is the right way to go to ensure that you have a right at the end of the day that you can assert and enforce. We can move on. So with all of that in mind, the diversity of Africa, the vastness of the continent, the various regional systems that are already in play, how does one approach a filing system to protect rights in Africa? We appreciate that there are very few brand owners or in-house legal teams that would have a legal budget allowing them to roll out a filing system in 52 countries all at once for all trademarks of interest. That simply isn't practical. So what we recommend is a tiered approach. What does that mean? It means identifying key jurisdictions as your first port of call. Where will we focus? Where will we go first to protect our rights? Then have a secondary tier. Perhaps that would be linked to a timeline. We'll look at tier 1 in the next year or two, tier 2 in the next 2 or 3 years, etc. But how do you determine which countries to place in which tier? That is a business question. Very first question to answer is the business question. Where are we operating? Which countries are of direct commercial interest? Where do we want to launch in the not too distant future? Do we have regional offices? Do we have licensees or distributors in these particular countries? That would shed a lot of light and help us to identify the key jurisdictions of interest as a first step. And then there are other issues that also need to be considered. And my colleagues have alluded to this in the previous talks, but many African countries follow a first to file system. That means that if a third party gets an application filed before you at the trademarks office, you will have a problem. On the face of it, this person is in a far stronger position, and you are now on the back foot, needing to reel in your rights and address this problem before you can actually protect your own rights and secure registrations. So in these first to file countries, also important to note, sometimes not possible, or at least on the face of the law and the current legal precedent, there's no recognition given to user rights or well-known rights. So what does this mean? No good litigator will ever throw up their hands and say, well, you're done for. There are certainly things that can be done, and these issues can be addressed. But we recommend a proactive approach rather than a reactive one. It is far better to make that investment at the outset in securing your rights, filing applications, than to have to come some years down the line to try to essentially win your own rights back and spend far more time, money, and effort in litigation to address a problem like this. Something else that we see, and that certainly must be considered, we monitor the trademark journals across Africa on a weekly basis. We are looking at new journals, and what we see from week to week is that the filing of well-known trademarks, essentially hijacking well-known trademarks, is a very common practice. And what I do seem to notice is that these trademark squatters appear to have their own filing strategy and approach, because they will favor first to file jurisdictions, countries where they know litigation will be difficult, costly, countries where they find themselves at an advantage as opposed to the genuine owner of the rights who now has to address them. What might the intention be? It could be an attempt at getting around anti-counterfeiting procedures, trying to register the mark so that you have a registration certificate and can circumvent any attempts to stop this conduct. Or it may be a business model of wanting to file well-known marks with the intention of approaching the bona fide and true proprietor, asking them to take assignment, but for a payment of money. So it's very important to consider all of these various moving parts that differ from territory to territory in Africa in devising a strategy for filing your trademarks.
Thanks, Nicole. Yeah, very much the same approach on patents, but quite important on the patent side, which we see not only enforcement is an important consideration, but also where the inventions are being practiced and where the inventions might form part of commercial transactions with multinational companies in joint ventures, and the patents are then used as leverage inside those types of agreement. But I think let's move on. We need to speed up a bit. So on the next slide, we talk about parallel importation, which is a difficult area. Like we've said, the situation differs in depending on the territory, and what we often see in most of these territories is the desire to make profit is the driver for the parallel importation. So if there is some price parity between the country where the product is purchased and then exported to the African continent, we see less parallel importations under those circumstances. In South Africa, out of a patent perspective, and we can go to the next slide, one will see that we've got national exhaustion of patent rights. So depending on the basis on which a product is sold by the patentee on a global, in a different jurisdiction, one can, in many cases, take action if there's a parallel importation of a patented product. So for South Africa, relatively on the patent side, some protection available. Nicole, on the trademark side, different issue.
Yes, a little trickier, Donnie. So the problem with parallel importation, or so-called grey goods, is that the goods are genuine. These are original goods. The trademark was applied to the goods by the proprietor of the mark, but they've simply come into the country through the unauthorized channel. So not through the authorized distributor, through a different channel. The outcome of this is that trying to address parallel importation through traditional IP enforcement mechanisms, whether trademark infringement or anti-counterfeiting measures, is not possible. There may be some scope, depending on the fact, to consider copyright infringement, but it is not a simple issue to address. That doesn't mean that nothing can be done. Certainly in South Africa, our consumer protection legislation requires parallel importers to apply conspicuous notices to any grey goods. Any listeners from South Africa will have seen on online retail websites, I know I see it regularly, as you access a particular product, the notice is there very prominent, and that is a requirement locally. That's something that we can insist upon. Another issue to consider is the regulatory framework. So if the goods in question are foodstuffs, liquor products, cosmetics, or pharmaceuticals, there is a local regulatory framework which dictates how these products should be marketed, what should appear on their packaging, and so on. Goods brought in from elsewhere may very well not meet the local requirements, and that's something to consider. Again, a proactive approach is always better than a reactive approach. So something we suggest is that brand owners look at their contracts with their distributors or licensees to make sure that this issue is somehow addressed. It must be clearly stated that the distributor is authorized to sell these goods in the authorized territory and not for purposes of being sold elsewhere. That would have a deterrent effect, and it at least gives the brand owner an avenue to address this with the guilty distributor through contractual mechanisms. If we move on to look at some other territories in Africa, to the next slide, Nigeria, of course, is a major market in Africa. And just as a general comment, brand owners would, at their peril, ignore Nigeria. A very big economy, there's a lot going on there, and it's imperative to secure rights in Nigeria to avoid trademark hijacking, to avoid counterfeit goods flooding the market, and to ensure that you are adequately safe with your rights in such a big economy on the continent. So what about parallel importation? The intention of the legislature in Nigeria over the years has been quite clear, that it wishes to encourage economic growth, free trade, movement of goods, etc. forms part of that. And so there's a definite reluctance to prevent parallel importation. This doesn't mean that it's impossible. And I will make mention of a case that was heard a number of years back, where a well-known automotive manufacturer took on a parallel importer in Nigeria and was successful in obtaining injunctive relief. The parallel importer was selling car parts for use in relation to these vehicles, but the important argument that was made was that those parts are not compatible with the vehicles that the manufacturer was selling in Nigeria. So vehicles transport human beings, there are safety concerns and a broader policy consideration that came into play, and their injunctive relief was secured. So never say never is what I want to get across on Nigeria and elsewhere in Africa. If we move on, we can have a look at Kenya, for example. It's a major market as well, and Kenya has really good IP protection mechanisms. We've had many successes in Kenya on an IPO and court level. Again, the courts are rather reluctant to prohibit grey goods or parallel importation, but as in South Africa, there are consumer protection and regulatory mechanisms that can be used. Then if we move on to look at Uganda, which is a very interesting country, Uganda has taken a rather different approach historically. So courts in Nigeria have looked at parallel importation in Uganda, and they've considered the notion of territoriality of trademarks as being particularly relevant, elaborating to say that the parallel importer does not have the right to sell goods bearing the trademark in the territory of Uganda, and therefore this amounts to trademark infringement. So this is a rather different approach. It'll be interesting to see whether the ethos underlying the free trade agreement perhaps impacts what happens in Uganda going forward. But what this does illustrate is that even on a legal topic that is relatively aligned on the continent, parallel importation, most countries have a sort of a similar approach and understanding to this legal issue. There are still differences, exceptions, and deviations. In countries where you might think you cannot stop parallel importation, you may find that in your particular case you can. So Africa is a continent to be considered closely. In order to provide practical and reasoned advice, one must really hone in on each specific country that is of relevance, particularly from an enforcement perspective. There is huge divergence and a lot of differing challenges and practices in place.
Yeah, thanks. And I think as a takeaway at the end, Africa, the various countries, there are a large variance in success rates, speed and predictability in the different countries. Lots of factors play into that. Things like access to the court system, the actual systems of the court. Some of them are still paper-based, some are digitized. The legal support, the legislation plays a big role, obviously. The expertise of the judges, and there we've seen a lot of work being done by WIPO, where a lot of funds and training has been ongoing in various countries of the judiciary. And the main theme that we are seeing is a constant improvement of enforceability throughout the continent. Some jurisdictions move faster than others, and the number of cases that happen and take place probably is driving that. But even in those jurisdictions where there are not that much enforcement work being done, we see a strong improvement in the systems and the enforcement systems legislation that we will use in years to come.
Yes, absolutely. But enforcement in Africa is certainly possible. We've done it. We are doing it. There are challenges, but Africa, as I think Ntabi said, has not been left behind. The landscape is clear.
So yeah, thank you very much from us. We'll probably deal with some of the questions at the end, and we're gonna hand over to Godfrey Budeli. Godfrey, over to you.
Thanks, Nicole and Donnie. Good afternoon, everyone. My task tonight, it's quite an easy one. I will be focusing on the Anti-Counterfeiting Authority and the recordal in Kenya. Now, I get often asked, what is the Anti-Counterfeiting Authority? The Anti-Counterfeiting Authority is a statutory created body in terms of the provisions of the Anti-Counterfeit Act of 2008. Although the act was passed by the Kenyan Parliament in 2008, it came into effect on the 1st of July 2009, and the ACA came into operation in June 2010. Part of the ACA's mandate is to combat counterfeit goods or counterfeit goods trade through several mechanisms, including criminal prosecutions of offenders as well as consumer awareness. Now, up until recently, the ACA used to have the powers to prosecute these offenders themselves. However, for a variety of legal reasons, that mandate has now been taken away from them and given over to the National Prosecuting Authority. It is important to highlight that the ACA does not operate in a vacuum or on its own, and it is supported by other law enforcement and regulatory agencies in Kenya. These include the Kenyan Revenue Authority, popularly known as Customs, the Kenyan Bureau of Standards, the Kenyan Copyright Board, the Pharmacy and Poisons Board, as well as the Kenya Trade Network Agency. Now, some of you may potentially be asking yourself, how is it possible the Kenyan Trade Network Agency is involved in the enforcement? Well, stick around, you'll find out in a few slides later. Now, the Anti-Counterfeit Act was amended to introduce a formal recordal process. In the past, we used to handle these particular matters informally with the ACA, and the intellectual property rights recordation function was introduced through the Statute Law Miscellaneous Amendment Act under Section 34B of the Anti-Counterfeit Act and the enabling regulations to the Anti-Counterfeit Recordation Regulations that were published in the Kenyan Gazette in 2021. Next slide, please. Now, move to the next one as well. Now, it is important that we look at that particular section to interrogate what it says. And you will see there it states that trademarks relating to goods to be imported into Kenya, irrespective of the place of registration, shall be recorded with the agency in the prescribed manner if the registration is current. Now, the law is quite clear that irrespective of where the trademark is registered, the ACA requires the proprietors to record their intellectual property rights for all goods to be imported into Kenya and to be sold there for commercial purposes. Now, the ACA implemented the formal recordal system on the 1st of January 2023. Therefore, it is an offense to import into Kenya goods where the intellectual property rights applied to such goods have not been recorded with the ACA. It is important to also point out that a formal mandatory recordal of this nature is the first of its kind to be introduced and implemented in the African continent, and to my knowledge, potentially the first in the world. As a result, there are some areas of conflicting interpretation, not only to the rules, but also to the Act itself. And there are some concerns that have been raised regarding the legality of some of the aspects, and I will point out those in due course. Next slide, please. It is not necessary to record each and every registered intellectual property right. It may be enough in some instances to record just the house brand, particularly in instances where the product incorporates the house brand, sub-brand, registered patent, copyright, and design. It is not necessary to also record the sub-brand, patent, and copyright and designs. It is therefore critically important that a thorough review of the intellectual property rights of the applicant, both locally and internationally, are thoroughly scrutinized in conjunction with looking at the product itself that has been sold in Kenya, so that an informed decision is made as to which specific intellectual property rights to be included in that particular recordal. And please bear in mind that it is not possible to record any pending applications. Although the regulations stipulate clearly that it is possible to record all types of registered intellectual property rights, the AIMS system, it is currently configured and or programmed to accept recordal applications based on trademarks only. In 2022, the ACA launched the Anti-Counterfeit Authority Integrated Management System, called AIMS, for testing purposes, and it also announced that the online recordal process will be rolled out in 3 separate phases. The first phase was to register agents. However, proprietors can submit the recordal applications directly, and there's no need or there's no requirement to undergo a registration process similar to that of an agent. An application to be accepted as an agent requires a relevant applicant to upload the following documents onto the portal. The first one will be the valid power of attorney, which must be or must have stamp duty paid, certified as true copy of the original, and notarized if signed outside of Kenya. It is necessary to also upload a proof of membership to a statutory professional body based in Kenya, like the Law Society, or proof of compliance with the Private Security Regulations Act. This suggests that only lawyers and investigators could register as agents. That particular application needs to be accompanied by a payment of 10,000 shillings, and upon uploading that application, the ACA will scrutinize it and then approve it if it is satisfied all the requirements have been met, and a certificate of admission will be issued to that particular agent. That particular certificate will be valid for 12 months, renewable at a cost of 5,000 shillings. The second phase pertains to the recordal of the mandatory recordal itself. And this has been implemented already last year on the 1st of January. The third phase has not been implemented. We're waiting for the date, which will be announced by the ACA. This will require that all the goods entering Kenya would be required to have the anti-counterfeit security sticker that will be applied to them. This will enable consumers to be able to scan those particular products as and when they are purchasing them to determine their authenticity. Now, it is important to look at the relevant requirements for submitting the recordal, because some of them are quite straightforward, but of course there are those that are quite tricky that needs some examination. There are 13 requirements that are stated in terms of the regulation. The first one is the details of the applicant. That's straightforward. The applicant who is applying for the recorder will have to supply those particular details. And obviously only the proprietor, as per the register, can record and can file the application to record its marks. The second one is the name and address of the agent. As I indicated, it is important for the agent to go through the registration process so that they can be admitted before they are able to assist clients in filing those particular recordals. The third one pertains to the name and address of each foreign person or business entity authorized or licensed to use the intellectual property rights in Kenya. Now, this information is quite critical, particularly because it will enable the ACA and customs officials on the ground to expedite container clearance processes and or to decide as to whether there is a need to temporarily stop it for verification purposes. The fourth one is the identity of the parent or subsidiary company or other company under common ownership or control. Now, that particular requirement is not mandatory. The fifth one is the original power of attorney. Sixth, samples and photos of the protected goods. The following one is the description of the IP, description of goods, details of the place of manufacture of goods. Now, it is important to also not indicate on the system where those goods will be manufactured. This is precisely to assist the ASEAN customs officials on the ground, where goods are coming in indicating that they are coming from Bangladesh, and on the system, the proprietor declared that all their goods comes from the US or China. The next one is the copy of the certificate of registration for IP or certified copy of the latest renewal certificate. Now, this is quite an interesting one because the ACA not only require that local trademarks be included, but international as well as foreign registration too. So this will mean that certified extracts issued by the Kenyan Intellectual Property Institutes will be required. And then for foreign and international marks, we will have to look at certified copies obtained from EU IPO, WIPO, ARIPO, or API, irrespective of the fact that Kenya is not a member to those regional systems. A copy of the certificate of incorporation of the applicant is also required. So a certified copy issued by the relevant authority or the certificate of good standing of the proprietor will suffice. And the applicant's tax registration number is also required, and this will be the tax registration number issued to the applicant by the revenue authority where the applicant is based. I often receive requests to clarify whether the tax number is that of the sister company in Kenya, but it isn't. And finally is the details of the manufacturer of the goods. And obviously, in many instances, these goods would have the manufacturing details reflected on the products themselves. And if the product comes through and there are details that are not matching, of course, that will cause the ACA officials or these customs officials to have a look into it. Next slide. Now, even before the implementation of the formal recordal system, there were concerns that were raised, and some of the local, regional, and international lobby and industry groups compiled a list and addressed it to the ACA for consideration and for possible review of the law. The first issue that was raised is that this particular recordal is mandatory in nature. And in principle, customs recordals are voluntary, and they do not create any offenses to the proprietors should they choose not to file their recordal. The second issue that was raised is that perhaps the ACA should consider limiting the rights that are recordable to those that are registered in Kenya, as opposed to including foreign and international rights as well, because doing so will undermine the principle of territoriality. The third aspect was to try and ask the ACA to relax request for certified extracts, as doing so will attract costs, and trying to negotiate with the ACA to see if they can't accept simple copy of the registration renewal or even extract copies of these particular rights. Filing a recordal with the ACA does attract costs. It costs about $90 to file a mark, as well as an additional $10 per each additional classes. So the ACA was asked to reconsider that to see if it's not possible to accommodate brand holders to file these free of charge, as is the case in many other jurisdictions. Taking into account the requirements that are quite onerous, plus the additional cost burden on the proprietors, the duration of the ACA recorder, which is 12 months, is considered to be too short, and brand holders and other stakeholders believe that it should be reconsidered to look at perhaps giving it a 2-year duration or even 5 years to ease the burden and administrative burden and the cost burden. And finally, the clarity on whether it is necessary to also record patents, designs, and plant breeders' rights, particularly because when we are talking about counterfeit goods strictly, we're looking at trademark and copyright infringements and not necessarily those. And there are jurisdictions where legislation specifically indicates that those other rights, patents, designs, and plant breeders' rights should be excluded for purposes of detentions and seizure of counterfeit goods. Now, to address the above concerns, either administrative or legislative amendments will be required. Those that may require legislative amendments will take time to effect, as it is a long process to change the law through Parliament. Although it is possible for IPR owners to submit recorders directly, in our experience, it is critically important that a practitioner familiar and able to navigate the AIMS system be instructed to assist instead. For example, for purposes of following up regarding pending recorder applications, it is necessary to log onto the AIMS system to review or to view the messages posted on the recordation review window, as there is no email correspondence directly into your email boxes. Of course, like in any other systems that are introduced, there will be teething problems, and the AIMS system is not immune to this. We have seen that there are areas where the recordal applications were loaded or captured onto the system, and there were some clerical errors. Those cannot be amended, and the ACA has advised that those should be resolved at renewal stage. The system is also not configured to generate logos, devices, shape marks, and so on, and it simply indicates that a particular mark is registered and described in words. Of course, that is a challenge, because if the system is to be used by officers on the ground, they need to see exactly which mark is recorded. I guess it will be important at a later stage for the ACA to consider that their system should perhaps integrate somehow with TIPI so as to not run a parallel process. Finally, the recordation certificates that are issued, they are pertaining to a particular mark as opposed to the recordal application. For example, if you file a recordal application consisting of 10 or even 20 trademarks, you will receive recordation certificates per mark as opposed to the recordal itself. Now that poses a challenge in a sense that some of these trademarks will be approved on different dates. That would mean that you would have different expiry dates, and you will then have to have a proper diary system to be able to follow up on that. Many other customs recorders, if you file it irrespective of the number of trademarks incorporated or included therein, you receive one recorder certificate to show that the recorder itself is valid, and should a trademark expire during the lifespan of the recorder, you just simply supply a renewal certificate for the authorities to update the system. Be that as it may, the ACA is aware of these issues, and its technical team is working around the clock to have them resolved. And I'm confident at some point these issues will be ironed out. The current status of the AIMS system is that it is up and running. but it's still unstable at times. At the moment, filing new recordal application appears to be functioning well or smoothly, though the systems still hangs every now and then. And in terms of processing of pending recordal application, the system is unfortunately unable to process approval of limited applications per day at the moment, hence the current backlog. Next slide. Now, I would like to...
Sorry, Godfrey, we'll be moving on to the next slide shortly. We are running a little short on time now. We are slightly overrunning. So if we could give a wrap up, if possible, as soon as you can, that would be great.
Yeah, I'm wrapping up. So finally, I would like to also explain the difference between the ACA recordal and the Kent trade system. I often asked, what is the difference between the two? Because the way in which they operate seems to be confusing. Now, the ACA recordal process involves the recording of existing registered intellectual property rights, mainly trademarks. And the Kent trade system is a completely different system. And just to introduce what Kent trade is that the Kent trade is a state-owned entity which was established to ease the cross-border trade through establishment, management, and implementation of national electronic single window system. The Kent trade system is an online window system that facilitates cargo clearance during the processing of imports and export of goods into and out of Kenya. It is considered a single window system because it brings together the multiple government agencies that are responsible for issuing permits, licenses, and certificates for purposes of cargo clearance. It serves as a single point of entry, allowing parties in international trade and transport logistics to electronically capture documents for processing and approvals and make payments electronically for fees, levies, tariffs, and tax payable to government on products imported into the country. And finally, the Kent trade system converge at a point, the Kent trade system and the AIM system converge at a point where the importer seeks to import branded goods into Kenya. Obviously, all the importers are requested to declare in advance all the brands that they intend to import. It is at that point that the Kent trade system will come into play. Now, part of that declaration will require that the importer must also upload a copy of the ACA recorder or recordation certificate. Now, obviously, that in itself could create a conundrum whereby parallel goods importers, they are finding themselves in a position where they will not be able to bring in parallel imported goods because they will not have access to the recordation certificate, which only the proprietor will have in a particular instance. And I probably foresee that there could be a challenge, but only time will tell. Thank you very much.
I would like to thank our panel members for hosting this webinar today, as well as the audience for joining. That is all. Thank you very much.